You're at will, so we can fire you for any reason. That's what your employer told you, but they're not telling you the whole truth. I'm Kira Fonteneau, and I'm an employment attorney who exclusively represents employees. Today, I'm exposing the 7 exceptions to at-will employment that could transform your legal termination into a powerful wrongful termination lawsuit. Most employees in the United States work at will, which means you can be fired at any time without notice for almost any reason, or no reason at all. But that almost is critically important because several major exceptions can turn a seemingly legal firing into wrongful termination. Here are the 7 key exceptions to at-will employment that protect you regardless of your at-will status. First, discrimination protections. Firing based on protected characteristics like race, color, national origin, sex, religion, age over 40, disability, or genetic information violates federal law nationwide. Other states may also have protection. It's important to know that some states have more protections than others. Second, retaliation prohibitions. You cannot legally be fired for reporting discrimination, harassment, safety violations, wage theft, or other illegal activities. This protection applies even if the underlying complaint turns out to be incorrect, as long as you made it in good faith. Third, implied contract exceptions. Employee handbooks, offer letters, or consistent employer practices can sometimes create implied contracts limiting at-will termination. Public policy exceptions. In some cases, you can't be fired for refusing to commit illegal acts, exercising legal rights like filing workers' compensation claims, or fulfilling legal obligations like jury duty. Those obligations may vary by state, and it's important for you to learn what applies to you. Family and medical leave protections. The Family and Medical Leave Act prohibits termination for taking qualified medical leave, and other states also have family leave protections beyond federal law. Whistleblower protections. Various federal and state laws protect employees who report violations of specific laws. For example, the Sarbanes-Oxley Act protects those reporting securities frauds, while the False Claims Act protects those reporting fraud against the government. Collective bargaining agreements. If you're covered by a union contract, you typically cannot be fired except for cause, as defined in your agreement. If you've been terminated and suspect your firing might fall under one of these exceptions, don't just accept that at-will means no legal recourse. Follow me for more workplace rights content and visit my profile to learn more. Remember, most wrongful termination claims have strict filing deadlines, and they're sometimes as short as 180 days. Don't let too much time go by and you lose your claim. And remember, at will doesn't mean no rights. I'm Kira Fonteneau, and I fight for employees' rights one case at a time.